is Paraná is cold. Rio is not cold, but Paraná, the south of Brazil, is really.
Yeah.
It's the only place in Brazil that snows once in a lifetime, but sometimes not in Paraná, in Rio Grande do Sul. It's souther than Paraná.
Yeah.
So I believe you're live.
Podemos começar? Como é que estão as... Como é que tá? Podemos... Porque eu não estou vendo aqui no canal que a gente está online ainda. Sorry about the Portuguese. I'm speaking with the IT guys.
That's okay.
It's a lovely mural in the background, Professor Mason.
It's my wife's
okay,
artwork.
so we've started the broadcasting, and so I'm really glad to have you all here today. We have professors from all the BRICS, from India, Professor Ajay, Professor Elizaveta from Russia, Professor Tianbao from China, and Professor David from South Africa, and myself from Brazil. Of course, I'm the least important here, but myself from Brazil. So let's just start with some acknowledgements here. This is the third of the CBMA, the Brazilian Center for Mediation and Arbitration International Webinar Series. So, and we have as co-hosts South Hero State University from Russia, University of KwaZulu-Natal from South Africa, Manav Rashna Faculty of Law from India, Yuhan University School of Law from China, and the RIEL, Research Institute of Environment Law, also from China. And I'm gonna just, present the speakers today. First, we have Elizaveta Gromova from Russia. She's professor at the Department of Business Law and Deputy Director for the International Cooperation of the Institute of Law of South Europe State University. She's also coordinator of the LLM program, Law and Digital Technologies. Her field of expertise includes digitalization of law as well as free and special economic zones. Ajay Thomas from India, Director of the Faculty of Law at Manav Rashna University, an independent arbitrator. He has had the unique privilege of working with 3 of the world's leading arbitration institutes, LCIA, SIAC, and SCMA, and has over 17 years of experience as arbitration administrator, arbitrator, and advocate. Professor Qin Tianbao from China. Professor Qin Tianbao is Luogia Professor of Law, serves as the Director of the Research Institute of Environmental Law, and the Vice Dean for the School of Law, Yuhan University, China. He's the Vice President and Secretary General of Chinese Society of Environmental and Resources Law, Editor-in-Chief of the Chinese Journal of Environmental Law, member and Vice Chair of the Compliance Committee of the Nagoya Protocol on ABS. And last but not least, Professor David J. Mcquoid-Mason, South Africa. He is Professor of Law based on at the Center for Socio-Legal Studies at the University of KwaZulu-Natal, Durban, advocate of the High Court of South Africa, visiting Professor of Law at Strathclyde University, Glasgow, Scotland, Adjunct Professor of Law, Griffith University, Brisbane, Australia, and President of the Commonwealth Legal Education Association, involving over 2,000 law schools in 54 Commonwealth countries. So thanks a lot for being here. It's an honor to gather 4 professors of the BRICS, and they represent really well their countries and their legal systems and their jurisdictions. And first of all, let's start with Professor David. He's on a tight schedule. And Professor, please, you can start. The stage is all yours.
Thank you very much. Just to say, it's a great pleasure to be back in Brazil, even in my imagination. I've spent a wonderful time in Brazil. And as we know, Brazil and South Africa have many things in common. Brazil is very close to the African continent. And for every 1 person who was sent to America from Africa, 5 people came to Brazil. That is why Brazil has the second biggest Black population in the world after Nigeria. So I always feel at home when I come to Brazil. My topic today is about legal education in the BRICS, in particular legal education in South Africa. And so, next slide, please. So what I'm going to talk about are the requirements for establishing law schools in South Africa, the requirements for admission to law schools in South Africa, requirements to become a lawyer in South Africa, best fields of legal practice in South Africa, key characteristics of the legal system in South Africa, and the main law school initiatives during COVID-19 in South Africa. And in each case, I'm going to make a small recommendation as to where I think the BRICS countries should cooperate in these different matters. I'd like to start then with establishing law schools in South Africa. Our law schools are accredited by the Council for Higher Education. We have 17 state law schools, 2 of which have 2 branches, plus 1 private law school. The accreditation procedure was developed by the deans, the Association of Law Deans, the legal profession, and the Ministry of Higher Education. So it was an all-inclusive process. And some of the criteria they looked at is what are your lecture and library facilities? What are your admission criteria? What is the ratio of professors and senior staff to other members of staff? What percentage of your staff members have doctorates and postgraduate degrees? What is your course content, your substantive law, your procedural law, and your clinical law courses? What are your examination strategies? And what is your throughput? How many people are actually graduating? What percentage? And lastly, because of South Africa's history, what is your transformation strategy? How are you encouraging more Black students in particular to come to your university? The accreditation itself is carried out by a group of deans who are our peers, together with representatives of the legal profession, Ministry of Education. So what I'm just basically recommending, because I know that some of you have got many, many law schools, but a lot of them are not properly accredited, and the BRICS countries need to enter into research and other partnerships with accredited law schools, not all these other ones that are springing up all over the country. Right, next topic is looking at admission criteria, I think. We have varying admission criteria. The universities can decide for what they want, but all students basically have to get what we call a matriculation university exemption certificate, which is the public school exam that they write. Some universities impose a slightly higher standard. My one, for instance, you want about an average of 60% or a grade of 60% to get in. We also take students from foreign countries. I had one Brazilian student who did very well. She ended up as an attorney in East Timor and a human rights lawyer as well. Barbara D'Oliveira, if ever you get to East Timor, Daniel. Students can take a 4-year undergraduate LLB degree, or they can do it as a postgraduate degree after doing a bachelor's course. If they do a bachelor's course where they've taken law courses, it only takes 2 years to do the LLB. If they have no law courses, it'll take them 3 years if they have a first degree. The important bit, I think, for BRICS is that most of our universities have postgraduate, doctoral, and master's programs, and some postdoctoral bursaries for people who already hold doctorates. And we really encourage participation from foreign students and candidates there. My university and many of us have environmental law, LLM programs, commercial law, medical law, intellectual property, tax law. There's a whole lot of offerings in South Africa. And I know that the South African universities would welcome BRICS postgraduate and postdoctoral candidates who can apply for their programs. Right, thanks. Next. Next one. How are you doing with the slides?
It's there.
Okay, how to become a lawyer in South Africa. We inherited the British model of a divided bar, that is solicitors and barristers. And we call them attorneys and advocates. An attorney is someone like a general practitioner in medicine. An advocate is someone like a specialist, and they appear mainly in the high courts. Recently, the government has tried to do away with these 2 branches and fuse them into one through a Legal Practice Act. But de facto, the division still continues. All our students have to get a South African law degree or equivalent. They have to attend a practical training school. They have to do an internship, and they have to successfully pass a national admission exam. The attorneys and advocates are governed by the Legal Practice Council, but they can form their own bar associations and have additional requirements for membership like the advocates do. So again, something I would suggest here, that those BRICS countries that have practical training schools, it might be quite useful to exchange some of the teaching techniques, particularly things like trial advocacy and so on, between them. Right, next one, thanks. Okay, the best fields of practice, I just pulled these out from the, just quickly, sorry, I pulled these out from the attorney's profession. Medical malpractice at the moment, I don't know if it's happened in your countries, but many Anglo-American countries, when road accident funds started becoming more accessible to people who've been injured and the attorneys' work diminished, they started focusing on medical malpractice. It happened in England, Australia, America, and so on. So in our country, the average earnings in medical malpractice cases by attorneys over the years, $267,000. So that's the top one. Personal injury comes next, $254,000. Workman's compensation, $226,000. Intellectual property, $224,000, and business. So those are the main sort of areas of legal practice. Again, for recommendation for BRICS mainly, if you have some lawyers practicing in these areas and they need maybe to do something because our countries are now trading more and more with each other, that you set up agreements with firms of local attorneys and they can do likewise with you. And I don't know if your countries have it, but our countries have a sort of attorneys directory of who specializes in what. Next slide, please. All right, key characteristics of our legal system. We're a constitutional democracy, ushered in by my friend Nelson Mandela. I was very lucky his son was my student, so I can tell you many Mandela stories, but I won't tell them now. So we have the Constitution as our supreme law, and our latest Constitution was the 1996 one. We were colonized by the Dutch in 1652 and by the English in 1806. So we have a mixed legal system. Our Roman Dutch law is substantive law, which is very similar to your law in Brazil. And I think also even in China and in Russia to a certain extent, they've got civil law systems as well. Our procedural law, though, is English and most of our modern commercial law, and that is similar to what India has. So we sort of bridge the BRICS countries in that. In our country, both the common law, that is our mixture of Roman Dutch law and English law, and the statute law, the laws passed by Parliament, have to conform with our Constitution. And in our Constitution, individuals can go all the way from a first instance court, district court, right up through the appeal procedures to the Supreme Court of Appeal, and it is a constitutional matter, right through the to the Constitutional Court as well. So there's individual representation all the way through. Again, a recommendation for the BRICS countries that are constitutional democracies or have a Bill of Rights. I think nearly all of us have some form of Bill of Rights, but we should actually share our court decisions. I know that in the civil law system, it's not tradition to rely on precedent, but it's still quite useful to see how your colleagues and judges in the other countries are interpreting similar provisions. So many of you will have very similar provisions to us because ours are all based on the International Bill of Rights, that's the Universal Declaration of Human Rights, and the two covenants on civil and political and socioeconomic rights. Next slide, please. Right, so what are our main law school initiatives during COVID-19 in South Africa then? Apart from having to adapt our teaching methods, and I think we've been speaking a little bit about this, the main law school initiatives have been in the field of clinical legal education, which is really where our university students and staff go out and serve the public, either by giving live client advice or conducting street law, what we call public legal education programs, as well as research initiatives. So our law clinics have found, for instance, that COVID has impacted in a whole lot of their traditional categories of legal work. Employment law, where people are losing their jobs because of COVID-19 lockdowns. social grants, people trying to apply for special benefits and relief programs under COVID. Human rights issues, and I've seen this, I picked this up particularly in India, and I don't know about other countries, but similar to ours, where the police and military tend to get over enthusiastic about people who breach the COVID regulations. We've also had problems with people being forced to go to government quarantine facilities when they've got quite adequate facilities available to them at home. And then in health law, which is an area which I've done a lot of work on, people being denied access to medical facilities like intensive care units, for instance, workers not getting protective equipment, refusing to work, people worrying about confidentiality, people worrying about informed consent. There are a whole lot of areas there which, if you're interested in, I've published recently in the medical journals, and I can refer you to them. And then gender-based violence, which in most of our countries, I think, has flared up again, particularly when you've got people all living together, locked down, not able to go out. So all of those are areas where our clinics have been working, as well as our street law programs. Next slide. Also, our research activities then. We've got a dedicated group at my university which focuses on COVID-19 and what the different academics in the law school are doing about that. We've been publishing articles in professional and academic journals to educate members of the public about healthcare professions. We're sitting on hospital ethics committees. I provide a lot of guidance and advice to hospital ethics committees on legal and ethical issues, and providing ethical and legal advice to individual colleagues as well. I don't mind individual doctors getting hold of me, because very often that ends up in some sort of article which you can educate everybody about. So my recommendation here is obviously that we should share our teaching and research initiatives regarding COVID-19. Right, last one, Daniel. So again then, just in conclusion, our law schools are all accredited and will be very keen to enter into joint research projects with our BRICS partners. Our law schools would welcome postgraduate and postdoctoral candidates from the BRICS countries. BRICS countries that are running practical training schools, we can learn from you and you can learn from us, I'm sure. Legal practitioners should consider cooperating with South African lawyers and vice versa in their fields of practice. We're a constitutional democracy with a Bill of Rights, and we have many similarities to other countries that have got constitutions and bills of rights, and we should share our court decisions to help each other. And then lastly, we should share our law school initiatives during COVID as well. Right, that's it, Daniel, that's everything. Thank you very much.
Thanks a lot, Professor David. And now, Professor Elizaveta. Hi there,
Yes.
Russia.
Greetings, everybody. Greetings from the National Research University, South Ural State University. I am so glad that no matter how long the distances are between us, and no matter what is the situation on our planet with this pandemic, we can communicate, we can collaborate, and we can share our ideas. I would like to today, can you see my presentation?
Yeah, perfect.
So today I would like to share, to give such an introductory course to the legal education in Russia. And of course, the plan will be the same as Professor Mcquoid said. Yes, first of all, we will begin. I would like to begin with the general information. Yes, here you can see the map of Russia, and you can see where is the South Ural State University located. And please pay attention on the table above. We can see the key features that regarding to the statistic, Russia Federation is in the 9th place of the population, and amount of the peoples who are busy in the sphere of law, of course it's an average. Yes, it's about 1 million people from Russia. So the amount of legal schools is about 7,700. Yes, also I want to share the statistic about the salary. So the salary for the beginner, for the junior lawyers, yes, it's about $1,400. And for the experienced and trained qualified lawyers, it's about $1,400. Of course, average. And regarding to the last figures, the amount of the graduates from the law school is about 100,000 graduates per year. So, firstly, I would like to share some features of Russian legal education. Our constitution, the Constitution of Russian Federation, provides the right to the education. It is said that, of course, everybody has a right to education, and everyone shall have the right to receive on a competitive basis a free higher education. And higher education in Russia is provided preliminary by the state. But of course, we have some private institutions, and it is regulated by the Ministry of Science and Higher Education. And we have some other features of the legal education in Russia. So if you want to become a lawyer, you can choose between 3 directions, or in some cases 4 directions. So it's a classic jurisprudence, or law enforcement, or national security, or in some country, in some university provides students with the program judicial expertise, as in my university. Legal education becoming more and more practice-oriented, because of course we are trying to prepare practice-oriented lawyers, and this is compulsory to share the experience of the practice of all the practitioners, and engage students in some practice-oriented events. Also, the legal education is mostly project-based. It's of course moral-oriented, universal, and we're trying that to make our legal education more international. So, what are the requirements for a law school in Russia? There is, first of all, if you want to, if I can say, create a law school, first of all, you should get a license. And we have a list of requirements. Among them are the law school must have necessary buildings, which belongs to the law school on the legal basis, of course. And the equipment must be safe. Everything must be organized for an inclusive learning. And educational program as well as methodological materials must be available, and the lecturers must be qualified. After 6 years of existence of a law school, the state accreditation begins. So it is held once in 6 years, the state accreditation, and the authorized body check the specialized classrooms, if the institute or university has an electronic educational environment, and also lecturers must have an academic degree or academic title. They must have scientific publications, and of course they check how practitioners involved in realization of this program. Of course, it must be a library, it should be available, and the software, of course, must be licensed and must be available for all the students. Except the licensing and state accreditation, we also have a novel. It is called professional public accreditation. This is independent assessment held by the National Bar Association. It evaluates the quality of competence formation under the educational program. It also assesses if there is a stable ties between employers and university, if our graduates are qualified enough to find a good job. Yes, it's also, these are all that is checked by the professional public accreditation. Talking about the second question about the requirements to become to future lawyers. Of course, the first requirement is education. And as you can see in this slide, if you want to become a lawyer, you should have, in some cases, it's enough to have a secondary vocational education, yes, to work something like a junior lawyer or a paralegal. And in other cases, you should get a higher education and bachelor's level, master's degree level, or it's sort of a Russian legal tradition. Before we entered the Bolognian system, we have a specialist. We do not have a bachelor's and master's. It was only specialist. And if you want to become a specialist, you should study for 5 years. So here is another scheme which shows us how can the future lawyer move in the education. And of course, it depends mostly on what does he want. So also for some kinds of professions, there is a specific requirement. So first of all, the minimal requirements for the judge, if we are talking about the district courts, for example, if being 25 years old, to have a higher legal education and working experience at least 5 years. If you want to become a prosecutor in Russia, you should be 25 years old, you should have a high legal education, and also the working experience 5 years. Oh, sorry, it is my mistake. It's 27 years old to become a prosecutor. And now it is very discussional and a very big issue in Russia, and all the Russian legal society discuss this because the new standard for lawyers was prepared recently. And this standard proposes the new requirements for a lawyer. For example, and if you want to be just a junior lawyer or a paralegal, it's enough to have a secondary vocational education. If you want to work as a lawyer or is in foreign analog as a solicitor, yes, to deal with the courts, you should have a high legal education. It's enough for a solicitor, it's not to deal with the courts. Yes, so you should have a high legal education as a bachelor and working experience is at least 5 years. So if we're talking, if a person wants to be a lawyer for courts or a barrister, this must be a high legal education, and here it is a master's degree or a specialist. So the problem is that a lot of members of the legal community argues, why do not we want to give the opportunity for the bachelor's degree students to become a barrister? So it's such a, now it's discussing broadly in Russia. Now I would like to talk a little bit about the features about Russian legal system. So actually nowadays in Russia, this issue is also discussional because our scholars argue about it. If Russian law belongs to the Romano-German legal family, or if our legal system belongs to its own, it is unique, or it belongs to Slavic legal system. Yes, but most of scholars agree that we mostly belong to the Romano-German family, and which is based, of course, on the reception of Roman law. And because of, if we can see on this slide, we are definitely suits to the peculiarities of the Romano-German family. So the main source of such a family is a legal act, as in Russia, of course. We have a written constitution. We have a clear branch division. All Russian law can be subdivided by on a public and the private law, of course. Also, lawmaking, a legislation as a function exclusively belong to the legislator. And now, before I start talking about the last question, yes, it was about initiatives of my law school during COVID-19. I would like to share with you the general figures about my university. So you can see here, we have a lot of international students, and we're developing the cooperation, the international cooperation. So, talking about the initiatives during the COVID-19, first of all, I should say that we were definitely ready for the distance learning, and we are so grateful for that because we have our own educational platform. It is called edu.susu. So this is a screen from this edu.susu, from this educational platform of the South Ural State University, where all our courses and course materials, literature, task for the seminars, everything is in this system. So it is very convenient for our students. They can stay safe at home during the pandemic and enjoy the studying process. So yes, here is another example. Like that, in system, there are all the necessary materials. And now, also, we are very proud of our legal clinic because when the pandemic starts, our students decide to make online consultation, which is very good. And also talking about other initiatives, well, as in other universities, as in other law schools, I guess all significant events such as conferences and webinar, of course, became online. And I should say that the pandemic doesn't stop our publishing processes, our researches, we still moving on. And by the end of my presentation, I would like to say that we are, as I told you earlier, we are National Research University. That is why the research is among our key areas. And we suppose that the good teacher, the good lecturer must be, of course, a researcher. And if he can research, if he can do research, he can explain the students a lot. And in my university and in my Institute of Law, also Ural State University, we have two research projects. They are really international. For example, we have international research project in legal tech. It's about legal regulation of digital technologies. It involves scientists from Russia, India, Italy, United Kingdom, Poland, Serbia, Slovenia, and Malaysia. And we also have another international research project about ecology. It also involves experts from Russia, Belarus, Kazakhstan, and Malaysia. Also, I want to share a few words about our partners. Yes, this is the journal who gives us opportunity not to stop our research and to publish our the results of our research work about this program. So it's a BRICS law journal. It is in Scopus. On that, I want to end my presentation. I want to thank you, all the participants, and all the listeners for your attention. So thank you so much.
Thank you, Professor Elizaveta. It was really nice to learn from you and from Professor David, and it's great news to know that we have a BRICS journal already.
Yes,
as
yes.
this webinar is. So all are welcome, all that are watching are welcome to publish in the journal quality research papers, of course. But that's a great initiative. How long does it have, the BRICS journal?
Well, it is our partners from Tyumen State University. It's not the journal of mine university. It's our partners, our friends, I hope. And the journal exists, if I'm not mistaken, from 2014.
Nice. So it's been a long time. It's been 6 years already. And could you stop sharing your screen? So
I'm still sharing. Sorry.
I think so. Okay, so thanks a lot, Professor Elizaveta, and I'm learning a lot here from all of you, and it's really nice to see all the different countries collaborating and having that will to collaborate between themselves, and including in the research field, in the law research field, in the legal field, and that's really great. Now, Professor Tianbao, the stage is all yours, and once again, I thank you for your presence. Yeah. Yeah, you could share. You were sharing the screen just now. No, now you got it. That's the PPT. Okay. Yeah, perfect.
Okay, thank you so much for the kind invitation for this very nice, very useful, and very event to share my understanding about the China's legal education and several other issues with all the wonderful colleagues. And I'm already benefit a lot from the introduction from the David and Elisa about the South Africa and Russia. Before I give the information about the China's legal education, I'd like to share some basic information about my city and my university. So this is the map of China, and here is the city of Wuhan. And I believe now you are very familiar with this word, with this city, because it was reported that the first case of COVID-19 was discovered in this city. And even now, I'm not so sure right now, because more and more scientific evidence shows that maybe Wuhan is not the origin of the COVID-19, but who knows? So you can see this is the enlarged picture of the city. You can see the city have a lot of rivers and lakes. So it causes a kind of river city in China. So here is the location of the university. And you can find that the university was just located along the very big lake in the city, which is also the largest lake within a city. So here's the location of the law school. The university was established in 1893. It's about 127 years old. It was built with the very traditional Chinese architecture structure, and you can see it's like a castle in a small hill. The university has about 60,000 all kinds of students, and we have a lot of different levels programs like undergraduates, master graduates, and PhD students. And we have about 4,000 full-time faculties, including professors and associate professors. The university hosts the most beautiful campus in the whole China, maybe not the world. And in different seasons, in the spring, in the summer, in the fall, and in the winter, it has different pictures, and which attract a lot of visitors, like a national park. The university's legal education can trace back to 1908. And it was formally established in 1926. It's almost 100 years old history. Now the law school has more than 100 full-time faculty members, 55% are professors. And the law school has more than 2,000 master students, 1,000 undergraduates. So you can see that we have more students as master students, even more than undergraduates. So this is the original law school building in 1920s, 1930s. And we have a lot of the international collaborations with American and European and even Africa countries, including the University of Russia. And now this is the new law school building. It's one of the largest law school building in China. My institute is called as Research Institute of Environmental Law. It was established in 1981, almost 40 years ago. So it was amazing because at that time, most of the people in China, I mean, maybe in the whole developing world, they have no idea about what is environment, what is environmental problem, what is environmental pollution. But at that time, the founders realized that the environmental law is a very important field and topic. So they established the very first Institute of Environmental Law in China and also in the Asia Pacific areas. And we hosted the very first environmental law master program and the doctor program in China. And now we have more than 1,000 graduates, including many important officials and scholars. So this guy is the chief negotiator on climate change. And we have a lot of the international staff and students also. The institute hosts a journal, an international journal, or in English called as Chinese Journal of Environmental Law. So I and Professor Mcquoid, the co-editors in chief. So the colleagues from all of the main reason we initiated this journal is that we want to provide opportunity and platform for the scholars from the developing countries, especially from BRICS countries, because we have already some journals on environmental law, but the majority of them are organized by the law schools, by the European countries or American universities. So we want to provide another perspective, another platform. So all the colleagues for this webinar and your colleagues are welcome to contribute to this journal. And we also started an English program for environmental law PhD program. And the Chinese government provided the scholarship to the students, especially from the developing countries. Right now, I have a PhD student from Russia and from Brazil, And we have several PhD students from African countries, but not from the South Africa, but from other African countries. Now I'd like to introduce the legal system of China. So you can see that China has the National People's Congress. So that means NPC is China's parliament. Under the parliament is the president of the China, and it has the parliament has the standing committee. Then have under the standing committee we have the executive branch, that is the central government, the state council. We have the Supreme Court. We have a Supreme People's Prosecutorate. So this is the structure of the China's the legal system. It's not the same like the separation of the legislative, executive, and the judicial. But in China, we have another type of separation of powers, but not the totally separated, but under the legislative is the executive power and the judicial power. And China is a country with a very strong tradition of civil law system. We study a lot of legal appearance from the Germany, from France, and later from the former USSR. So all the countries are civil law countries. So China has also the characters of the civil law countries. Now we have the constitution, which is the fundamental law in China. Then we have the law issued by the People's Congress. And then we have the administrative regulation, which are normally issued by the central government. And we have departmental regulation by the departments and the ministries of the state council and local laws. In addition, right now we also allow the judicial power to issue some interpretations on the application of certain laws. So it is also regarded as law in general, as a part of the legal system. According to the current new system of the Chinese court, we have generally we have Supreme Court at the national level, and we have the High Court, Supreme Court, and High Court. Say Supreme Court. We have High Court and Intermediate Court and the Grassroots Court. So 4 levels. This is for the general courts. Now we also have some special court for this, for example, for military, for environment, for railway and transportation, and also for the maritime. So this is a special court system. This is a general court system. So normally we have 4 levels. So grassland, intermediate, and higher at the provincial level, and the national level is Supreme Court. The model legal education actually was introduced in China as part of the political reform in end of 18th centuries, and in 1920s to 1930s. So the influence of both the continental and Anglo-Saxon legal system was introduced in China, and unfortunately during the decades long the Cultural Revolution, the legal education in China was blocked, and the resume of the legal education was restarted in 1980s. We have an increasing number of law schools and their capacity to offer the higher quality legal education. Till now, we have almost 600 law schools in China. So I understand this is a typical different from the situation in Russia, maybe, and in South Africa. If I remember, the law school, the number of law schools in South Africa is less than 20, but in China we have a 6,000, 600. The reason is that the China is a big country, and we have a lot of bigger population, 40 billion, 1 billion population, and we have 2,000 or 3,000 universities in the whole China. So 1/5 of them can provide the legal education. We do not have the creation system in China, but normally you need approval from if you want to provide the master and the PhD levels program. If you just provided the program on the undergraduate, it's fine. It's dependent on the university, not by the Ministry of Education. But for the top university, normally they have the largest attractive force for the students to study in their universities, in their law schools. So as to the teaching method, normally is delivery of lectures is a very common method. And second is we provide the legal clinic and or the field trip. We try to combine the law and the practice. And we also have the moot court, and for different fields, for international law, arbitration law, and environmental law, and labor law, and commercial law. We have a lot of moot court competitions. And we also have a very good international method. We have a lot of international staff members, and we introduce the teaching measures and the teaching facilities from the advanced countries in legal education. Yeah. So normally we have 3 levels of legal education. It's undergraduate, master degree, and the PhD degree. So for the master degree, for the undergraduates, we call it LLB program. Is normally 4 years. In the whole China, we have about 38,000 students, and we have another 3 years LLM program, and also we call it a JM program. LLM program is more focused on academic research, and the JM program is more focuses on the legal practice. So this JM is similar to the JD system in US. So we have about 25,000 students every year in the whole China, and we also have the 3 years LLD program, also called as the Dr. Yura program or PhD. So we have 60,000 a year in the whole China. The law school at the undergraduate level, we provide a lot of courses. For example, we provide compulsory courses and the optional courses. So the compulsory courses, we provide the jurisprudence, legal history, constitution, administrative law, civil procedure, criminal law, criminal procedure law, and environmental law, economic law, business law, and public and private international law, international economic law, intellectual property law. And more recently, we also provide the labor law and the social law as a compulsory courses, because this is a new issue with the rapid development, economic and social development. If you want to be a lawyer, practice lawyer, you must pass the we call it China's national judicial examination. This is a national examination. It was established in 2002. Before that, it was the we call it national bar examination. It was established in 1986. And if someone passed the examination, qualified to be a lawyer. But since 2002, the examination was reformed as the National Judicial Examination. That means if you want to be a lawyer, want to be a judge, if you want to be a prosecutor, you must pass the SAD examination. So the qualification of this national judicial examination provided you opportunity to 3 different directions as lawyers. I mean, the practice lawyer and the judges and the prosecutors. Normally, the examination lasts 2 days and 24 hours. It was seen as one of the most difficult professional examinations in China. And it requires a very comprehensive knowledge and law and ability to write very well. So only around 10% of examinees pass every year. Since 2018, we changed the rule. Before, anyone who has a bachelor degree can join the National Judicial Examination. But since 2018, the examination was limited only to those one with law degrees from the full-time universities education. With some very exceptional is the with 3 years of work experience in the so-called legal institution. For example, if you work in the very local level in legal assistance or legal aid institutions, you can take part in the examination. Or you have the bachelor degree or master degree of law, then you are entitled to take part in the examination. So that was seen as the China tried to guarantee the professional and legal nature of the national judicial examination. The best fields of the practice currently is the finance with the fields with finance economy. For example, finance, securities, companies, investment, taxation, trade, real estate, and they are very popular. And most of the lawyers actually are working in these fields. But in future, I think we maybe have more fields. For example, it's AI, it's artificial intelligence, internet, and intellectual property, and also the energy and the environment, and the international cases could be new fields of practice for the lawyers. During the COVID-19 period, the law schools, or the whole China, the law schools provided the virtual teaching system. So we can find all the law schools, not only my university, but also other universities, they provide online teaching courses on also for the master sisters and the PhD sisters defense. They also use the online system. And the whole law schools in China organize a lot of academic researches and events. For example, this is a academic event with human rights protection on the pandemic prevention and control, the principle of proportionality. We have several colleagues from the China, from Russia, from the US, from Brazil to talk about the said topic. And we also organize several research projects to study the legal issues arising from this COVID-19 situation. For example, the COVID-19 and the government response, COVID-19 with human rights, with the environment, with competition, with digital society, with tax, with health care system, etc., etc. And another benefit of the COVID-19 is very interesting that almost all law schools provide online public lectures series. So before, each university, each law school have their own lecture system. They normally will invite the distinguished professors from other universities to give lectures in their university to their staff members and to their students. But this time, because the COVID-19, they cannot organize the the face-to-face lectures. So they invited the professors, distinguished professors or practitioners to deliver the lectures online. So they found the beneficiaries could be not only their own students and staff members, could be the general public. So almost all the student universities changed their strategy. They invited professors, the lecturers to deliver deliver online totally publicly. So everyone who want to study, who want to learn something, can join in the lectures. So perhaps this model could be a new normal model even after the COVID-19, because everybody has been used to this system. That if I want, I can listen to the lectures, and if I have no time, we have even record. You can review the lectures. So that is a very interesting situation after this during this COVID-19 situation. So that's my very quick very brief introduction about the China's legal education, legal practice, and the teaching and the research situation in the COVID-19 situation. And if you want more information and if you have questions and comments, I will be very pleased to communicate with you afterwards. Thank you.
Thank you, Professor Tianbao. It was a very complete presentation about China's legal education and about China's legal system. So I've learned a lot here, and I'm pretty sure everyone else did, which is a system that everyone should know a little better, especially if you're from Brazil, because China is #1 commercial partner with Brazil. So if you want to be a lawyer on the BRICS areas, China is, of course, it shouldn't be the first, but you should know a lot about China, and also from South Africa, Russia, and India. And that's the key objective goal of this webinar, to put in Brazilian students' minds, and of course in your students' country, they should know a little better about your systems. They should know a little better about your systems and study your legal system, so they can perform better during negotiations and contracts and whatever they want to do as lawyers. And thanks a lot, Professor Tianbao. And now from India, Professor Ajay Thomas, please, the stage is yours.
Well, at the outset, let me express my sincere gratitude to CBMA, and especially Professor Daniel Brantes Ferreira and Professor Ajay Gaved for your kind invitation. It's an honor and a pleasure to be here today, to be sharing my thoughts with you on the legal education scene in India. So I'm going to make a very small presentation. It's not going to be very lengthy, on law, lawyers, and legal education in India. So as Professor Daniel introduced me at the very beginning, I am the director of the Faculty of Law at a private university in the National Capital Territory region of India called Manav Rachna University. What I'm going to be looking at is starting off with the Indian legal system. Now, when you're looking at the Indian legal system, it is said that India has had a legal recorded history dating back to the Vedic Ages. Now, the Vedic Ages is a time somewhere between the late Bronze Age and the early Iron Age, between 1500 to 500 BC. So law in ancient India was seen as essentially a matter of philosophical discourse or as a matter of religious prescription. And if you look back to ancient India, there were ancient digests called the Smritis. Law in ancient India, to a large extent, the codified laws was contained in law digests called the Smritis, Smritis. And so that was ancient India. And if you were to fast forward to the present day modern India, our legal system to a large extent is based on the English common law system. Now, if you look at a map of the world and you look at the various legal systems around the world, the ones in brown or red are jurisdictions which follow the common law system. So common law system, to a large extent, as most of you know, is a legacy of British colonial rule. And if I were to look at the BRICS countries now, I believe with the exception of South Africa, which essentially is a mixed legal system, India happens to be the only BRICS country which has a predominantly common law based legal system. And by virtue of being a common law legal system, judicial pronouncements or the principles of stare decisis or precedents play a very, very important role in understanding the law of the land. Now, if you were to ask me what are the key characteristics of this Indian legal system, I would essentially say that the grand norm for all laws in India is the Constitution of India. And the Constitution of India is essentially the guiding light on all matters relating to the three wings, the executive, the legislature, and the judiciary. Now, the Constitution of India does not have any express provisions relating to the separation of powers between the executive, legislature, and the judiciary. But in reality, you do find a bifurcation and a division between the powers and functions of the executive, the legislature, and the judiciary. If you look at personal laws in India, now the personal laws in India to a large extent are not uniform. They are to a very large extent based on the religion of individuals. For example, the law relating to Hindus, the personal law relating to people professing the Hindu faith has been codified, but the law relating to Islamic precedents is to a large extent based on commentaries and precedents and not on a code. So we do not yet have a code relating to Islamic law in India. So we don't have a uniform civil code in India as yet, excepting for one state in India, that is my home state called Goa. Now Goa, as most of you might be aware, for 500 years was ruled by the Portuguese. And the Portuguese civil code, even today, governs the personal laws relating to the people living in the state of Goa, irrespective of their religion. So Goa is the only part of India where you have a uniform civil code relating to people's personal rights and laws and matters relating to personal law. Now, if you were to look at the Indian legal system, another characteristic is that it is essentially adversarial. Unlike the continental systems and the civil law systems, which to a large extent are inquisitorial, the Indian legal system follows its British English common law roots and is largely adversarial, excepting with respect to certain functions. For example, the criminal justice system in India it's not strictly adversarial, but you find a blending and a mixture of both the adversarial as well as the inquisitorial systems. Now, if I were to move on to the Indian judicial system, we have an integrated, single integrated judicial system, the Constitution of India divides the Indian judiciary into the superior judiciary, which comprises the Supreme Court of India and the various high courts. And then you have the subordinate judiciary, which essentially refer to the district courts and other courts that function under the district courts, which to a large extent are governed and administered by the respective territorial high courts. The Supreme Court of India is the apex court of India. It's located in New Delhi, and it is presided over by the Chief Justice of India. Now, as most of you would be aware, India is the system of governance in India is quasi-federal. You have the central government, and then you have 28 states and 9 union territories. And each of these states has a high court each. But there are certain states, there are certain high courts which have jurisdiction over multiple states. But otherwise, essentially, if you look at the larger, more dominant provinces or states, each one of them have a high court each. Now, you might ask me, what is the correlation between this photograph that you see on your screen and the Indian judicial system? So, ladies and gentlemen, there is a very, very intricate relationship between what you see on your screen and the Indian judicial system. Just like this utilitarian vehicle on your screen, which is overburdened and on the verge of collapse, similar is the current state of affairs with the Indian public justice system. And that to a large extent is because of this huge pendency of cases pending in the various courts in India. If you see the pendency of cases in the district courts, the high courts, and the Supreme Court of India, there's an astounding 34 million cases pending in the various courts in India. And it is precisely for this reason that the wheels of justice in the public justice system in India move ever so slowly. And if you were to look at reasons why the public justice system is so laggard, one of the reasons is because of the vacancies of judges in the various courts. Now, what you have on your screen are statistics relating to the vacancy, the sanction strength, and the working strength. And from that, you can decipher the number of vacancies which are there at the various levels in the public justice system in India. And this is one of the primary reasons why the mainstream public justice system in India, reflected by the courts, is considered to be extremely slow and inefficient. Again, if you were to look at the judge to population ratio between India and the more developed nations of the world, the ratio of judges to every million people in India is only 17. For every 1 million people in India, we have only 17 judges. And when you compare that with, say, a country like the United States of America, where you have a ratio of 105 judges per million, this perhaps explains also why the public justice system in India is so slow. And ladies and gentlemen, it is precisely because of this reason that the public justice system in India is considered to be relatively inefficient, that in recent years there has been a great push and a movement towards encouraging arbitration and alternative means of dispute resolution. And in a recent speech, one of the grand old men of arbitration in India, senior advocate Mr. Fali Nariman, he is said to have said that, and I quote Mr. Nariman, "The future of arbitration and ADR in India is bright because the future of litigation perhaps is not." So it is because of this reason now you find that even the judiciary has been in the forefront of encouraging resolution of disputes, especially commercial disputes, through the medium of arbitration and alternative forms of dispute resolution. And the judiciary has also taken the lead in establishing an institutional mechanism for resolving disputes outside the court system by establishing court-annexed mediation centers and also court-annexed arbitration centers. And is arbitration the first choice when it comes to resolving commercial disputes in India? There were a few studies conducted in India. 2011, there was a study conducted by Ernst & Young, which showed that 74% of contracts in India had an arbitration clause. In 2013, there was another study conducted by PricewaterhouseCoopers, and this showed that 91% of the companies surveyed preferred arbitration and not litigation for the resolution of future disputes. And ladies and gentlemen, the popularity of arbitration and ADR as a form of dispute resolution can be gauged by the valet parking coupon on your screen. Now, if you were to carefully look at this valet parking coupon, it relates to one of the best Bengali cuisine restaurants in Delhi called O Calcutta. And the last paragraph of these valet parking coupon, if you were to read it very carefully, it says that all disputes shall be finally settled in India through arbitration conducted by a sole arbitrator, duly appointed in accordance with the Indian Arbitration and Conciliation Act of 1996. So ladies and gentlemen, what you find happening in India is that arbitration and ADR as a form of dispute resolution is not only restricted to high-value international commercial contracts, but you also find arbitration clauses now in mundane, day-to-day contracting situations. And so if you were to ask me, what is the future of dispute resolution and the legal profession in India? My answer, I may be slightly biased because I come from a commercial arbitration background and I also sit as an arbitrator now. But if you were to look at this astounding backlog of cases in the public justice system in India today, it is no surprise that the government and the judiciary, and now backed by the commercial entities, are all rooting for arbitration and ADR to resolve their commercial disputes. And this is extremely important because when you're looking at legal education should meet the requirements and necessities of the profession. And when you see a focus now by the industry, by the bench and the bar on resolving disputes through the medium of ADR and arbitration, I think this is a cue that the formal legal education system in India should also adapt itself to meet to these changing exigencies and circumstances when you're looking at the legal profession in India. Now, if you were to look at legal education in India, I think India, perhaps after Brazil, has the largest number of law universities and law colleges in the world. At last count, there were more than 1,600 law colleges and universities in India. We have almost 150,000 law students who graduate every year. And in a recent interview of the chairperson of the Bar Council of India showed that the current number of registered lawyers in India is around 2 million. So that's a huge population of lawyers that we have in India. It is said, now I live in the capital region of New Delhi, and it is said that in New Delhi, 1 in every 300 people in New Delhi is a lawyer. And on a lighter note, it is said that when the courts are closed in New Delhi, you find the traffic on the streets of New Delhi is incredibly thin. That shows the amount of lawyers constituting the population of the capital of India. And this to a large extent is because the Supreme Court of India is located in New Delhi. All the specialized tribunals dealing with specialized matters such as income tax, customs, competition law, and all these specialized areas of the law, all these national tribunals are located in Delhi. So if you were to ask me which city in India is the legal capital of India, unmistakably the answer would be New Delhi. Whilst the commercial capital of India would be Bombay or Mumbai, the political and administrative and legal capital of India is unmistakably Delhi. Now, if you're looking at the legal education system in India, at the undergraduate level, there are basically 2 types of law degrees which can entitle you to practice the law. You have a 3-year LLB course, which is the traditional LLB course, the traditional way of being eligible to be a lawyer in India. And to take a LLB course, the eligibility is that you have to be a graduate in any discipline. So you can be a graduate in sciences, in the arts, in fine arts, in engineering, in medicine. You can be a graduate in any area of any discipline. That would be the basic criteria for you to get into this traditional 3-year LLB program. Now, this was a traditional mode. About 35 years ago, somewhere in 1985, there was an experiment to introduce integrated undergraduate degrees, which led to you being eligible to join the legal profession. And this was an experiment which started off with a law school in Bangalore called the National Law School of India University, which was established way back in the late 1980s. And the experiment here was that this was an experiment in offering you a multidisciplinary integrated approach to learning the law rather than a traditional specialized approach to learning the law. So here what was offered was not a 3-year LLB degree, but you were offered an integrated BA LLB honors degree or a BSc LLB honors degree. So you had 2 disciplines, 2 degrees which were fused into one integrated 5-year course, where at the end of 5 years, the student graduated with not only an LLB, but also a first degree, which could either be a BBA or a BCom or a Bachelor's in Science, and also maybe a BTech, Bachelor's in Technology. Certain institutes in India have experimented with merging the study of engineering along with law. So the difference between, in terms of eligibility, between the traditional LLB course and the integrated 5-year BA LLB or a BSc LLB course is that the eligibility for these 5-year courses is after your class 12 exams, or what you call the O-level, in the common law systems, or what is basically your high school, perhaps in America. So here you have students in the integrated undergraduate degrees getting into specializing in the law at a much younger age rather than doing it at the postgraduate level, which is what happens with your traditional LLB degrees. And this experiment to a large extent has paid off, because there is qualitatively a big difference between the students who graduate from a 3-year LLB course and those who graduate from an integrated undergraduate law degree course. So these are the two essential streams of courses which entitle you to be called to the bar or to be registered with the bar. Now, talking about being registered with the bar, you have an organization called the Bar Council of India, which is a statutory body established under a 1961 statute called the Advocates Act. And it is the Bar Council of India which regulates legal education and the practice of law in India. So if you were to look at a regulatory body relating to legal education as well as the practice of law in India, it would be this body called the Bar Council of India, better known by its abbreviation, the BCI. Now, the Bar Council of India is an elected body. Its members are elected from amongst the lawyers practicing in the various courts in India. And if you were to look at the regulatory and representative mandate of the Bar Council of India, you do have a whole list of activities and functions which come under this mandate. But the two most important functions are that the Bar Council of India lays down the standards for professional conduct and etiquette for advocates. It also, when you're looking at legal education, it has the responsibility to promote legal education and lay down standards for legal education throughout the jurisdiction of the Republic of India. Now, when you're looking at enrollment of advocates, so how do you become eligible to practice the law in India? Now, eligibility, as I said earlier, you need to either do a 3-year LLB course or an integrated 5-year LLB course from a recognized law school which is accredited by the Bar Council of India for you to be admitted as an advocate. So the first step in becoming an advocate or a practitioner of the law in India is that you need to have a law degree from a recognized and accredited law college. You need to then go to the State Bar Council. You have the Bar Council of India, which is at the federal level, and at each state level, we have 29 states in India. At each state in India, 28 states, my apologies. At each state in India, there is an individual state bar council. So you get your LLB degree, you go and enroll yourself at the State Bar Council. Now each bar council has its own rules relating to enrollment of advocates. For example, I'm enrolled with the Bar Council of Maharashtra and Goa, which is a joint bar council for the states of Maharashtra, of which Bombay is the capital, and also for the state of Goa, which is my home state. So once you take admission or enrollment with the State Bar Council, you need to take an All India exam, which is conducted by the Bar Council of India. This is called the All India Bar Exam, AIBE. This is an examination which was introduced only as late as in 2010. It's an examination which is held biannually, and to a large extent, it's a test of advocates on substantive and procedural laws in India. If you successfully complete this All India Bar examination, then you are given a certificate of enrollment. And with this certificate of enrollment, an advocate has a right to practice the law as an advocate in any high court in India or any lower court within the territory of India. You also have a right to argue matters before the Supreme Court of India, but you cannot file an application or a petition in the Supreme Court of India if you do not take another exam, a specialized exam called the Supreme Court Advocates on Record examination. So all filings in the Supreme Court of India can be done only if you successfully pass another examination called the Supreme Court Advocates on Record examination. But otherwise, if you have to go and argue a matter, orally argue a matter, you don't need anything other than your certificate of entitlement to go and argue a matter in any court within the territory of India. So that was about the legal profession. And my last slide is on the impact of COVID-19 on legal education. Now, let me give you an example of my own university and how we dealt with this whole menace of COVID-19. Now, on the 14th of March, as soon as we realized that the pandemic was getting worse, the university was shut down as a precautionary measure. There was a national lockdown introduced on the 24th of March. And that's when we realized that this is a situation which is an extraordinary situation, and it is not going to end anytime soon. And that's when the university management took the decision to go online with our classes. So in the last week of March, we started experimenting with various platforms to conduct our online classes. We looked at Zoom, we looked at Google Classroom, WebEx, Microsoft Teams. And finally, we zeroed in on Microsoft Teams. And that, ladies and gentlemen, is the platform that Manav Rachna University today uses to deliver its online teaching modules. Now, we have gone online not only with our with our teaching systems, but we've also gone online with examinations. Our odd semester end-term exams were successfully completed in the first week of May on our internal ERP system. We have an iCloud enterprise resource planning system called ERP system within the university. So we successfully completed all our end-term examinations on this ERP system. We are now experimenting, as I speak to you right now, there is an online proctored examination, a midterm proctored examination, which is going on right now. For example, what you see on your screen are a few screenshots of the proctoring process, where we've got proctors who are supervising the conduct of these examinations so that the examinations are conducted in a fair and transparent manner. So as you see with the proctoring system, we have a combination of the pen and paper model along with an online system. And so this, ladies and gentlemen, is a time where we are experimenting with various platforms. We have, when it comes to our admissions, to this 2020 intake, which starts sometime soon, our entrance exam to our university was done entirely in an online format. We used artificial intelligence proctored online format provided by a company called Metal Mercer. And we successfully conducted examinations, the entrance examinations for almost 10,000 students by using a purely online artificial intelligence proctored examination system. And when you're looking at, my apologies, when you're looking at the system, the continuation of the learning systems during COVID-19, I must say that we successfully completed our past semester in the midweek of May, and we began our even semester in late May, and we will continue with the learning and education process until end of September. So what we did, the university management decided to skip the traditional summer break or the summer vacations, and we decided to combine the summer break with the winter break and give our students as well as our faculty a long 3 months break in winter, by which time we are hoping that the COVID-19 pandemic would have subsided. So ladies and gentlemen, this is how we at the Manav Rachna University and the Faculty of Law at this university have dealt with the disruption in a normal learning and education process which has been brought about by COVID-19. It's said that every dark cloud has a silver lining. So ladies and gentlemen, the dark cloud of COVID-19, the silver lining is that we have been in a position to utilize this downturn, if I may say, or these extraordinary circumstances to explore the potential of online teaching, online working, online networking. And the very fact that I am here today speaking on legal education with leading representatives and professors from Brazil, from Russia, China, and South Africa is I think one of the highlights or the silver lining of this dark COVID-19 cloud. And at the university, at the Faculty of Law at Manav Rachna University, over the last 3 months, we've conducted almost 25 qualitative webinars, including a series with UNCITRAL on various aspects relating to the work of UNCITRAL in harmonizing and modernizing commercial laws. So ladies and gentlemen, let me end with a slide of the premises or the faculty building of the Department of Law. So what you see on your screen is what we call the globe on campus. That is the building which houses the Faculty of Law at Manav Rachna University. So on that note, ladies and gentlemen, I would like to once again thank CBMA for this kind invitation. And in more normal times, I would like to invite all of you to come and visit us at the Faculty of Law at Manav Rachna University. And I hope we will continue to have this online dialogue and which probably in the months to come, we can also move offline. And that would be a fantastic achievement of this initiative, this initial initiative, which has been taken up by CBMA. So Daniel, on that note, I hand the floor back to you.
Thanks, Ajay. It was a great presentation. As always, I had the opportunity to watch another presentation of yours, and I've learned a lot from India. And I always say, I have some friends from India, and even though we're far away, we're very similar people. You guys from India, you love soccer just as we do. And you have our buses there, as you told me once. You have Marco Polo buses around India. You told me already. India has Brazilian buses, Brazilian-made buses around there. So that shows the commercial partnership that India and Brazil already have. So thanks a lot for your presentation. And I'm just gonna say that Jair is sending hello through the YouTube channel, and he's watching all the panel here. Our friend Jair Jevar, the International Director for Academic Affairs of the CBMA. And he's asking a question here. Of course, I'm gonna make my presentation, and then you guys can answer. But just so you think a little bit, Ajay already answered it in his presentation, but his question is, how is ADR working in your legal systems? That was his question. So I'm gonna make my presentation here, and then you can answer. ADR, he's asking about mediation, arbitration, maybe the Singapore Convention, and the New York Convention, and how is ADR working there in China and Russia. Unfortunately, Professor David said he was on a tight schedule and he had to leave. But if you guys can answer that, that would be great. And also, I would like to thank the president, the Brazilian Center for Mediation of Arbitration President, Gustavo Schmidt. He's also sent his hello, and he thanked you all for the presentation here. And he's really glad to have you here today, as we are all. And I'm gonna share my screen here. Just, can you see it? All clear? Okay, so here's my email and of course my name, and I'm the Brazilian the Brazilian Center for Mediation Arbitration Vice President for Academic Affairs, and also the Editor-in-Chief of the Brazilian Journal of ADR, Alternative Dispute Resolution, which is a CBMA initiative. So, and I invite you all to publish in our journal. If you want more information, just email me and I'll gladly answer it. So first of all, I'm going to talk about the BRICS and its importance a little bit. I'm going to bring some numbers about it, and then the status of legal education in Brazil and requirements to practice law and best fields, and latest trends and challenges brought by COVID-19, especially in legal education and CLE, clinical legal studies. So just some data on the BRICS, and that impressed me a lot when I was researching it. We have 40% of the world's population. The 5 countries together make 40% of the world population. China and India, they are the top 2 in population. China has almost 1,500,000,000 inhabitants, whereas Brazil is the 6th with 200, closely 200, a little bit more than 200 million population. And Russia is the 9th in the ranking, and South Africa is the 25th. So we make 40% of the world population. That makes us, of course, strong. And we have 30% of the GDP in terms of purchasing power parity, PPP. So we are a great part of the world's economy, 30% almost of the world's economy. So cooperation is necessary if academic and commercial cooperation is necessary. And I got the numbers of the law schools here in Brazil and all the BRICS, and as a comparison, I brought some other countries. Brazil is the leader from numbers of law school. We have almost 1,800 law schools, and we just have 200 million, a population of 200 million people, which is a lot. I would say that it's too much. We have too many law schools here in Brazil. But the Bar Association fights a lot against it. You know, they say that we should close opening. The government shouldn't open any more law schools. But you know, it keeps authorizing, the government, the Minister of Education keeps authorizing new law schools. Well, I don't agree with that entirely, because I think you should open good law schools. You should authorize new good law schools, but not all of them. What happens is that you have an instrument, an evaluation instrument, that if you fill those items, those 55 items, you can easily open a law school. If you have a good pedagogical project, if you have 10 good professors, law professors with master's degrees and PhDs, and if you have a good infrastructure, if you rented a good building and everything, you have a good online library. The library today can be all online, and that changed a lot, you know, in terms of costs. So if you have all that, you can open a law school, and of course you need to have an university, not a university, but an educational institution authorized before. But you can do both process of authorization together. You can ask to authorize your institutional education, your education institution, and the law school together. And China, Professor Tianbao said you have 600 law schools. I got these numbers a little bit more, but of course I'll go with your number. But even so, your population is 6 times our population, and you have 1/3 of the number of our law schools. Russia is close to 1,000, and India 1,600. So together we have more than 5,000 law schools. If you put the 5 countries, South Africa has 19. So just to compare, the United States has 237 law schools. So I think we have too many in Brazil. And of course, can you hear me all right? Can you hear me? Okay. No. Hello? Can you hear me, Elizaveta?
Yes,
Is it
everything
good?
is great.
Because one person from CBMA, everything is great. Can you see my screen?
Yes, I can see your screen.
Okay. So it's perfect. Sorry about that.
I can see your presentation.
Because one person from CBMA just called me and I said, maybe something is wrong. Let's see what happens.
No,
What's happening here.
That's okay.
Okay. Thank you, Elizaveta. Thanks a lot. So let me keep going with my presentation. So these are the numbers of the law schools here. And total BRICS law schools, we have more than 5,000 law schools in the BRICS countries. So we have a lot of room for cooperating academically speaking. And Brazilian legal framework is divided in public universities and private universities. So we have more than 2,000 private universities, and all the states, most of the states actually have public universities, and public universities in Brazil are completely free. So we have 26 states and one federal district. So 22 out of the 26 states have state universities here in Brazil. And we have 69 federal universities in Brazil. Of course, I'm not saying all of them have law schools, but most of them do have law schools, and they're completely tuition free. So you don't pay anything to study in a public school. Even if they're state or federal law schools, they are completely free. But the test to pass, we have a national test to pass to enter in the public university. They're not easy. So mostly only the best students get in the best law schools, of course. And our legal education system was inspired by the Portuguese. Of course, we were colonized by the Portuguese, and we had the first lawyers in Brazil came from the University of Coimbra and from Portugal. They went to Portugal to study and came back and work as lawyers here in Brazil. And in 1827, actually in the 11th of August of 1827, like today is the Lawyers' Day in Brazil. We had the foundation of the first two law schools in São Paulo and in Olinda. Olinda is in Pernambuco, is a state of the northeast of Brazil. And as the university model, the Brazilian university model was inspired by the Napoleonic model, which means we used to have, that's getting better, but used to have individual college, separated college inside the university. They didn't communicate that well. That's a lot better today. And the law school system was influenced by the Portuguese law schools, of course, because the first professors and the first lawyers were from Portugal, made their law schools in Portugal. And as the law schools nowadays, we have, of course, the law. We are a country based by statutes and codes. We are a civil law country, and we have the main law for education that we call the foundation of the law it's from the 90s. But for the law schools, we have the national curricula guidelines that to open a law school, to build a curriculum, you have to respect those requirements. So we had the first one in 2004, and the last one is from 2018. And just so you know, in 2018, we had included as mandatory courses mediation and arbitration, for example. They weren't mandatory back then in 2004. And of course, you have other mandatory courses as civil law, criminal law, tax law, all those dogmatic classic courses, they are mandatory. If you want to go extra, if you want to put a course like digital law, that's an option just for the students and for the law school. They're not obliged to do that. Of course, they have to certain requirements to fulfill, but so the minimum requirements for a law school here in Brazil, they must have, it's a 5-year course. So you cannot graduate in the bachelor's degree before 5 years. And that's actually, you can in really special occasions, but usually you go through the 5 years, and they have to respect a minimum of 3,700 hours. A law school cannot have less than 3,700 class hours. So and you have to build the law school, to authorize a law school, you have to have a didactical pedagogical organization. So where you put the courses that your law school is going to have, and you have to have a good faculty. And the requirements, usually you can only have professors with master degrees and PhDs. If you have a professor that only has a bachelor degree, the evaluation is not going to be that good. And you need to have good infrastructure, library. And to begin with, to open the law school, you don't need to have the clinical legal education already established. You just need to show the project, where it's going to be and when it's going to be built. So you just need to have a preliminary infrastructure there. So, and the pedagogical project must be divided in 3 main axes: the general information, the technical legal training, which is the courses that are dogmatic, that are technical, and the practical profession training, which is the clinical legal education. And clinical legal education must be performed in the last 2 years of the course. So when you are a 4th year student and a 5th year student, you are there in the clinical legal education system of the law school. And clinical legal education and additional activities must represent 20% of the workload of the course. So to be a lawyer in Brazil, you need to have the bachelor's degree, the 5-year course. You need to be approved. You have to have your diploma, and you have to pass the bar exam. The bar exam in Brazil is national. So it's the same exam in all the 26 states. And there's no difference at all. And if you pass the bar exam, you can be a lawyer in the whole country. It's not like in the US, for example, that you need to pass the state bar exam, and you only can be a lawyer in that state. No, it's a national bar exam, and it's the same exam for everyone. And usually law schools, if you get the total number of law schools, they're gonna have between 10 and 20% of approval, of percentage of approval in the bar exam, which is not good. The best law schools have 60%, 50% of approval in the bar exam. So if you want to go to the best law schools, you gotta see which one of them have 40% and over that 40% approval rate. So I can talk a little bit about legal education in 3 different professional perspectives, because I'm from the accreditation site body of the Ministry of Education, of the Brazilian Ministry of Education. So I go to the site and I authorize the law schools to begin their operation or not, representing the Ministry of Education. And I'm a former law school dean, so I know how the dean and the law school administration body thinks. And I'm a former bar president of the Legal Education Committee. So beginning with the Bar Association in Brazil, both national, we have the National Bar Association, we have the states branches of it. And state councils. And the Bar Association is completely against this opening of law schools. And they have the reason, because we have too many law schools. But if you see, most of the law schools are here in the richest part of the country, in the south and the southeast of Brazil. So I don't know how many we have here, but I think it's like 1/3 of the law schools in the whole country are located here in the southeast and south of Brazil. So I agree with them, but I don't think you should bar any law school to be authorized. I think you should increase the requirements, put it a little higher to open a law school. It's easy to open a law school, to authorize a law school as it is today. If you have, of course, infrastructure and money to invest, you can open a law school. And as a law school dean, a former law school dean, and I was mainly concerned about the numbers. Which numbers I was concerned about? The academic numbers. So I tried always to put my approval rate in the bar exam the highest I could. So I trained the students for that. And there's a national exam that the government makes to test your students every 3 years. And that rate is also important for the law school and for any other discipline and in other college. So, and those are the two main academic parameters that we need to work in the law school, of course, and see what the students are learning, if they're really learning, and if you're giving them a good formation. And the other numbers that I was concerned was the financial numbers as a law school dean. So you have to control how many students enter in the law school, how many students leave, how many students abandon the law school, and why that's happening. So you can provide the best service ever and the best professors for them to learn and to get the best results and the best formation. And as an accreditation site body member, you have to follow the rules. You have to follow those 55 items, and you must be objective. You don't have discretionarity there. So if you have the requirements, you will open a law school, and there's nothing anyone can do about it. You have the requirements, just fill them, and that's it. You're gonna have a new law school here in Brazil. And how about online legal education? Law schools are forbidden to be full online, at least during normal times, not during COVID. During COVID times, they are all online. And during normal times, they only can have 40% of the courses online, so in the online format. But now, during COVID, all the law schools went online. There's nothing we can do about it, and most of them are using these apps: Zoom, Blackboard, Collaborate, Microsoft Teams, and Google Classroom. So, and I think that's happening in the whole world. And I think it's not about being online or being face-to-face education. I really think it's about having good professors. If you have good professors, it won't matter at the end of the day if it's online or if it's face-to-face, because good professors will answer their students, will give a good class, will teach a good class, and will be clear in their lectures. So I think it's not about being online or face-to-face, and these times are showing us that. And I need to talk about the Sistema Faculdade, which is from great professions, made by great professionals, and they helped a lot during COVID-19, especially in clinical legal education. And because one of the main reasons that the Bar Association, the National Bar Association, they don't want legal education to be full online, because institutions already want to make legal education full online here in Brazil. But one of the main reasons is because of clinical legal education. The Bar Association, and I agree with that, say that it needs to be presential. It needs to be face-to-face. So that they have the reason, and I think they're right. But in times like that, and even in normal times, systems like this one help a lot, because this system, you can practice multi cases inside the system, and the professors, they can evaluate the students in the best way. They can see all the skills and competences through the system, and they can the dean can see what the professors are doing. So it's a really good system for clinical legal education and for legal education for online. So if you can mix during normal time face-to-face clinical education and online clinical education, I really think that's the best way to go. And Sistema Faculdades does a great job with that. And just as a final note, as we're talking about the BRICS, I got this quote from an American politician, Robert Green Ingersoll. He said, he's from the 19th century, he said, "Commerce is the great civilizer. We exchange ideas when we exchange fabrics." So if we already exchange fabrics, and we have all our countries have this great commercial relation, I think the academic and relation we must produce more and must be more partners in this way. I know we are already, but I think we need to increase that. In that way, maybe sometime in the future, the financial center of the world can be the BRICS, not Europe and the US, because we are 40% of the population and 30% already of the economy. So I thank you guys a lot for hearing me. And if you have any questions, just let me know. Hi there. We are back. I'm sorry about the interruption there. Someone from CBMA called me and said maybe there's some trouble with my presentation, but everything was okay. So just to answer Jair's question about ADR, what do you think about mediation, arbitration, and other forms of dispute resolutions, negotiation, of course, conciliation? And I know India is pretty similar to us. I was studying India legislation on arbitration, and their law is from the same year as ours. Our Arbitration Act is from '96, and we had a good change in 2015, just as you did also in India. But India had another one in 2019, if I'm not mistaken. But we have where the acts are pretty similar from India and Brazil, of course. Brazilian Arbitration Act is inspired by the Spanish law from 1988, and of course got some parts from New Citral from the model law, but other than that, we're pretty similar. I think arbitration is one of the good ways, not mediation, also one of the good ways to. Hi there. Hi there.
Hello.
What's your name? What's his name?
It's Hendrix.
What?
Hendrix.
Nice. Say hello to him.
Thank you.
Do you speak Cantonese or Mandarin with him?
Mandarin.
Mandarin.
Yeah.
So if you can answer that question, and we'll be glad to hear it. Elizaveta?
Well, I can try.
You can.
Yeah, in Russia, we have a system of alternative dispute resolution, although it is not that popular as far as I understand in your countries. Because I think it is connected with the mentality of the Russian people. I think we believe that if we want a fair decision, we should go to the court, maybe. But now I found interesting material that during the COVID, the interest to the alternative dispute resolution grows, and especially to the online alternative dispute resolution. And they have some list of organizations in Russia who do this online. So that's all.
Thank you, Elizaveta. Professor Tianbao?
Yeah. So you mean the application of ADR in China, right? Yeah. Actually, China is a country of with the model legal system. I mean, the history is not very long, no more than 150 years. It's quite a long history. China used a lot of different means to settle dispute, and we have a strong tradition to use the so-called alternative dispute resolution means, such as mediation, negotiation, and so this culture and historical characters affect our dispute settlement very much. So after introducing the model legal education, China began to use the litigation as the main way of the dispute settlement. But we still, especially in the civil society, the people prefer to use the mediation and arbitration and several other ways to solve the problems, solve the disputes. And officially, China introduced the arbitration in the 1980s also. And the arbitration is very popular right now, especially in settle the commercial and economic issues, and also for the labor issues, and sometimes the environmental cases, and also the mediation. Mediation, we have two types of mediation. One is the mediation out of litigation. So that is a parallel with the arbitration and litigation. And we have also we call it a judicial mediation. This is before the judge made the final decision, made the award. And the judge could organize mediation between the two parties. And if they reach kind of mediation, the judge will endorse that. So that is a very, very useful, way to incorporate the so-called ADRs in China. And especially China also encourage the use of ADR in China. So we should not put every dispute into the court because, as the largest population in the world, we have a lot of courts at the grassroots, a lot of local courts, but we still have limited judges, limited judicial resources to solve the problems. And within the philosophy of a harmonious society, so the central government and our legal philosophy is to encourage all different ways to solve the problem peacefully, and only necessarily we go to the courts. Right now, the litigation is very popular in model cities, in commercial and other economic fields. But for some, the western areas, in the remote areas, they are still using some existing mediation and arbitration and several other ways of dispute settlement. So I think it's all the different ways of dispute settlement are very useful and popular and encouraged in China right now.
Thank you, Professor. Ajay already told us about the how arbitration and the multi-door tribunal is important in India, and so it's like that in Brazil. We have an 8 million lawsuit backlog. So for big disputes, arbitration is being used a lot. Big B2B, business to business. Of course, I'm kind of against using that in massification, like consumer arbitration. And Brazil law also forbids consumer arbitration, for example, but it's authorizing certain, if the consumer wants it and everything, but not in the arbitration, previous arbitration agreements hidden in the contract. Let's say, let's put it like that. But other than that, any final remarks, professors? I would like to thank you a lot. I learned a lot today from you. Really, we're gonna have some other webinars, of course, and you are already invited. As Professor David also, he sent me a message here. And thanks a lot for your presence. And if you have any final remarks, please feel free.
Well, I have one final remark. Well, this is just the beginning of a dialogue between all of us. And it would be fantastic if this dialogue probably were to end someday, maybe a few years down the line, with the establishment of a BRICS law school. And I tell you why it's an interesting concept, because in South Asia we have a grouping called SAC, South Asian Association for Regional Cooperation, which has got 7 member states of the South Asian countries. And about 10 years ago, SAC established the South Asian University in New Delhi, which is basically a university comprising of, or rather, which is jointly run by these 7 member states of SAC. So I'm just thinking aloud, God willing, someday, maybe this discussion could take us to the establishment of a BRICS law school, which I think would be a very appropriate and logical conclusion to this conversation which has started here today.
That would be a dream coming true. That would be fantastic. And we already have ADR institutions from the BRICS, and the president of the Brazilian, of this center of CBMA, is the president of the commission in Brazil to establish the BRICS ADR institution here in Brazil. So that's going on really well. And I think a law school, a BRICS law school, with the cooperation of the whole states and the various academic cooperation, that would be a dream come true. That's a nice idea, Ajay. So, anyone? Elizaveta?
Dear colleagues, thank you so much for the center, for the invitation. And it was a great honor for me to know all of you, Professor Tianbao, Professor Ajay. Thank you so much. I hope we will collaborate further.
You all have a standing invitation to the center, and I hope to see you in Rio sometimes, you all. Professor Tianbao comes a lot to Rio. He already told me that. And Ajay, you need to come here. And Elizaveta, of course, and Professor David also. Thanks a lot, guys. And I hope to see you, everyone else soon. Thank you.
Thank you.
Thank you.
Bye.
Bye-bye.
Bye-bye.